Welcome, everyone. My name is Bobby Fazy. I'm president of Insight Law. I'm an estate and business planning attorney. And the topic for this program today is the truth about estate planning. This is the Insight Law client orientation meeting. You are watching this video or listening to this audio video because you are interested in exploring estate planning with our firm. You either were not able to attend one of our live sessions, or you're just coming through the online version. And so this program will last approximately an hour, give or take, but it's structured to be about an hour program, and it will go over, and I am, Robert A. Fazy is my legal name, but call me Bobby, and any type of emails or follow-up this program was going to go to Michelle Tice at M like Mary, T like Tom, at insightlaw.net. And so you're going to find that I'm a very blunt attorney. Most estate plans just don't work, and we'll just get started just like that. And how would you plan? How would you know if your plan worked or not? Maybe a better question would be, when would you know? And a lot of people will say, well, I'd be gone by that point. And again, today is about estate planning. And so I want to focus you. And so what we use is the snapshot test. I'm a very visual learner. And so I want you to visualize the time after you passed away and you're looking down from your cloud from above. All my clients look down. They don't look up. Beats the alternative, right? But if money's going where you thought it would be going and people doing what you thought they'd be doing, then that's generally a plan that worked. Money not going where you thought it'd be going and people not doing what you thought they'd be doing, then that's generally a plan that didn't work. And most people come in with the snapshot test they have their own thoughts and views on it. My goal today is, we've done this before and we've done this for many years, is to show you some of the common pitfalls and issues that we have seen, and so that you have you are given more information to make an informed decision on your side. So one of the things before I get started, I do want to go over with you, or one of the items that I do utilize is selecting and working with an estate planning attorney. So let me show you this sheet first. And so this sheet this is the questions, and everyone will get one of these. If you are listening to the video and want it, you can request it. It's just a selecting and working with estate planning attorney questions. These are the questions that I would be asking an attorney, knowing what I know or being in the market for one. Everyone asks about price, but there's about 14 other questions you should be asking the attorney. And the goal today is to go through those questions. And so I'll check back in and let you know, at least you'll know our answers, and you'll be armed with why we're asking those questions for yourself. Okay, so back to the presentation. So typical planning trap is people focus on just the documents. What documents do I need? I need a will, I need a trust. And but my point of this is that don't get caught up in these typical traps as far as what documents you need, wills, trusts, getting into all those battles. Focus on the results. And this slide here about Chip and Joanna, the fixer-uppers, I'm a big fan of this show. It's on TV all the time. The reruns are on now. And they're just basically a couple that Joanna is the one who will come and sit down with the clients who are looking, or if they want to remodel their house or they're building a house. Hey, what's your vision for the house? What's your vision for the kitchen, the bathrooms? And she's really the one finding out what the goals are for the client. And then Chip is her husband, and he's the one with the tools. He comes in and implements and creates and makes the kitchens and the like according to their goals. And my analogy is just a very simple analogy between remodeling homes and estate planning is don't focus on the lawyer's tools too much. The tools are the legal documents. So the trusts are the tools, wills, powers of attorney, those are different tools. Focus on the results. And so anytime you've done a remodel, if you've seen that show, has anybody ever asked Chip what type of tools is he going to use to make the kitchen happen? No. And so we're focused on the results, and that's the main thing. So another typical planning trap is, I don't have a tax issue. My estate's not large enough for a tax, so I don't need any planning. That's a common misconception and common concern. Tax is just one of the issues. And so there's a whole host of issues that we'll go through that you need to be aware of. And if all of those issues aren't of a concern for you, then you can make the informed decision. But I find those decisions or those issues are more important most most of the time. And then the transfer trap is, I just want to avoid the probate or court process after death. Probate is basically a court supervisor government audit of your affairs after death. And it's completely voluntary. If you structure your affairs right, you don't have to go through that. And so that's one of the things that we will address. But if it's just the only issue that you want to deal with, then how can you accomplish that? And are there other goals that you're missing by being short-sighted on that? So on our side of it is just really, what we find is that people don't really have an understanding of all of their options, and that's today. Today is where we're going to show you a lot of the options, common options that people aren't aware of. And then working with a firm, hopefully you'll work with us. But again, by just listening to this video, you can't be a member of our firm. It has to be a mutual decision. This is just informational today. And so the typical planning trap, again, is people focusing on the taxes or just focusing on the documents or just focusing on avoiding probate. And those are good goals to have, but let's look at the whole picture and let's come up with a plan that makes sense for you. And so let's start with the fundamentals. And the first question I would be asking an attorney if I was looking to work with them is how they define estate planning, right? And so this is our definition of estate planning. This is not in Webster's dictionary or Black's Law Dictionary. This is the National Network of Estate Planning Attorneys definition. I'm an instructor with the National Network. And I really like this definition because it covers all the issues. So start with the fundamentals. If you don't remember anything else, this is what estate planning is about. Number one is I want to control my property while I'm alive and well. A plan for me and my loved ones if I become disabled. Then I want to give what I have to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. So, there's a lot there, but if you understand that definition and why we are structuring it that way, you're going to be fine and the plan's going to work fine. And so the first part is about control, and most of our clients value control, and so that's important. And then number two is disability planning, as a lot of people miss this one. I am going to be frank again, and I'm going to say that it's much easier to deal with your estate after you're dead than if you're disabled, because if you're disabled, you're still here, right? We have to take care of you. There's a whole host of different issues. What kind of care? Where's the money coming from? And so you need to think through disability plan. Hopefully you'll be one of the lucky ones that doesn't have to deal with it, but let's make sure we've thought through the issues proactively so it's not a fire drill or a mess if that time comes. And then I want to give what I have to whom I want, when I want, in the way that I want. And I find a lot of people don't understand their options on the way that they can leave their assets, their loved ones. And once they've been educated on that, then they see, okay, I can really open up my planning. So we're going to show you that today as well. And we try to set the bar high. We want to pass on your non-material wealth as well as your material wealth as well. The stories, the values, the life lessons. So that's our definition of estate planning. And our counseling philosophy, how we approach that definition, is everyone we work with in our firm, any of our prospective clients will work with you, start you from the base of this pyramid and work your way to the top. And so the most important issues are categorized towards the bottom. Is first getting to know what your situation is, right? Your goals, your hopes, fears, and concerns. The analogy I use is that with the estate planning, it's just like if you're on the airplane and what they say is when there's a sudden and unexpected loss of cabin pressure, when the masks come down, put the mask over yourself, then take care of your loved ones. Same thing with estate planning. If your plan doesn't take care of you, we're not getting to the family, okay? We're not getting into those issues. So make sure you're covered. Hopes, fears, concerns, how your disability plan is going to be covered. Then we can get to the family. If you're married, how is the spouse with finances? How is the spouse's health? Who pays the bills? Who handles the investments? And then if there's kids, are the kids minors or are they adults? Whole host of issues, different issues for minor children than adults. For minors, you need to be worried about guardians and trustees. And a lot of time, the life insurance money needs to be figured out what to do with that money. Okay, here's a pile of money. Now, what do we do with it? And then the guardian issues and trustee issues, child care powers of attorneys, appointment of interim guardians. let's keep child custody services out of it, okay, child protective services out of it, and let's keep the kids with your family. And then if the kids are older, how are they with money? Age doesn't necessarily equal experience. How do they get along with one another? How are their marriages? If they're married, strong, shaky. Are there any health issues that we have to be aware of, special needs issues that we need to be aware of? So once I know the lay of the land, then we can look at ways of preserving wealth, expanding wealth, and saving taxes. If you have a financial advisor that you work with, that's a great place to have them be part of the discussion in preserving and expanding wealth, and it's going to make your plan even that stronger. And so we're very committed to being team players and collaborating if that's your situation that you have right there. But preserving wealth, a big common issue with preserving wealth is that let's say you have a married couple situation, one spouse has a catastrophic illness. Well, how's the money going to work? What's the care going to be for that other spouse? How's life going to look like for the healthy spouse? So these issues we don't want to be focusing on or trying to figure these out during that time. And so this is about proactive planning to make it a lot easier. And taxes are important. If you have an estate tax issue, great. We'll make sure we'll address that and minimize it to the greatest extent possible. You just need to be aware there's other tax issues that if you've done your planning, it's been a while since you've done your planning, the laws have changed a lot, and the landscape has changed a lot. So you just need to be aware of it. So the basic idea with the planning pyramid is you teach us, the family, moving up the pyramid, we'll teach you the law, and together we'll make the plan work together. So there's 4 keys to an effective estate plan. This is what I'll be talking about today. Is number 1 is get good personalized counseling. And I say that as opposed to or versus word processing. And so if you're looking for some word processing documents and just looking for biographical data being spit out into some forms, I would say go to LegalZoom. Don't pay an attorney for that. The attorney should be bringing something to the table of value. And I'm going to give you some examples of what I mean by counseling and word processing. And so what value do you put on that as far as avoiding some disasters and the issues that are concerned with it? Proper asset ownership is another critical point to estate planning. Most people miss this as well. There's only 3 ways you can own your assets: your individual name, jointly, and by contract. That's it, okay? And so there's different ways that you have your instructions laid out and how your assets are titled or how things are going to play out. And if they're not coordinated properly, there's going to be issues. People get caught up on the contract one. Contracts examples are IRAs, insurance, 401ks, annuities. Anything that has a beneficiary designation typically associated with it are contracts. The bank's transfer on death designations are the bank's contracts or payable on death designations. Be careful what you wish for with regard to that, because you get their contract. And how often is a bank's contract really in your favor? So proper asset ownership, really critical. Number 3 is a formal review process. Formal review process is let's take a look at the plan every so often once we got it set up. Traditionally, this has been a common pitfall with estate planning, is that attorneys are really not great at communicating with their clients. And so when the initial plan set up, when they got the delivery of the legal documents, typically was the end of a relationship with the attorney. That's not the way that we work it. That's the beginning of our relationship. It's a relationship-based approach because I'm hoping that the plan does not have to be implemented right when we sign it. I'm hoping it's many years down the line, so that's going to evolve. The plan's going to evolve. It's going to get tighter, and we're going to grow with you as a firm, and we're going to be there with you. Versus it's a one-and-done thing. There's no updating, no follow-through, no communication with the attorney. And then people think to 20 years later, they come back to this document that occurred 20 years ago, and that's going to actually work. And why does this cost so much? And why is it not working? Because the planning was not done right, and the typical hourly billing model by attorneys, people would not call back the attorney to update it because they didn't want to pay the attorney or didn't think it was worth it. And so we're going to show you how we address all of that. We have a membership type of approach. It is optional, so take it or leave it. But just know if you leave it, what the consequences are, and then what your options are when you do take it. And then a controlled transfer process. You probably wouldn't be watching me today if you didn't care how things kind of worked out, either at a disability or death. And so let's get blunt again. If you were to die today, how prepared is your family if something were to happen to you today? And that's really why we're here, right? And would they have any idea what to do, how to do it, and how to pay for it? Really? I mean, because that's the point to our law firm, is when we get that call on the death notification, and we want to tell our clients, whoever is making that call to us, the family member, the spouse, whoever it is, we want to let them know everything's in good order. You just be with the family. Final arrangements were done. Here's where they're at, or we can point them in the right direction. When you're ready to come into the office and take care of the legal side, schedule a meeting. We've got that covered. We've got a process to get you through all of that. And we've done this before. This is what we do. And so it's not everything's in pretty good order. We think everything is all set. That doesn't cut it. And so it's not about the documents. It's about the results and having a good firm or having support for your family during the most difficult time to get them through that. Okay, so those here's 5 major ways that you can plan that's out there in the world that I'm aware of. You can do no documents. That's not a very good approach, because then you're taking the government's giving you your plan. You can do a simple will, and POA stands for power of attorney. Then you can do a will with testamentary trust and power of attorney. So stay with me. A last will and testament. A testamentary trust is one that's created after death, versus a simple trust. Some people call it a living trust, is one that's created during lifetime. I label it as simple because there's not much counseling into these types of trusts that are being sold out there. And then the modern approach is really just about process. The documents are free, but does the process support your family when they need it most? Disability, death. Is it smooth? Is it what you envision as far as the goals being taken care of? Easier for the family, easier for the spouse, less of a hassle. So it's those are what I see that are out there. These middle ones are all document-based, focused on the documents, bare bones planning. Again, don't focus on the documents so much. Documents are important, but focus on what the results are going to be. The 4 most common challenges that I see in the estate planning world, number 1 is mental disability, bigger and bigger deal. And so it's just a different host of issues, and you can be dealing with it in many different ways. One is you could be younger and dealing with family members on that. Or you could be older and dealing with a family issue like that on your own, or dealing with a family member issue as well on that zone. How does the disability, if someone's disabled, what kind of care are they going to get? What kind of care do you want? Where is the care going to be? What resources do you have? How much of, what do the people that you've designated in the various roles need to know? How much of their time is it going to take? And then asset transfer on death is a very big issue. So most people don't title their assets properly, and gets tied up in court, or it goes to different places than they thought it was, because no one was keeping their eye on the ball on how the assets, the fine print on the titling. And then taxation. Everyone wants to minimize taxes, so we'll show you what's up with the taxes. And then achieving your personal planning goals, whether it be protecting the inheritance from the kids' creditors or predators, giving them investment assistance, protecting it against Medicaid, having the inheritance go on for generations or not. Those are all dealing with your goals that we would go through. So our approach is a 3-step approach. Is first, develop the plan with counseling-oriented planning partners. We call that the empowered design. Let's really supercharge that design and make sure you're aware of all the options and have been thoroughly counseled on them. Number 2 is commit yourself and your family to a continuing maintenance and education program. Every so often, let's just make sure that we can empower your legacy by keeping the plan up to date. I will show you our response to that hourly billing model. We don't do hourly billing for it. We just use a flat fee, and it's optional. And then once the inheritance is received, empowering the inheritance, secure what we say is secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. That's the key, right? Securing appropriate assistance. What does that mean in your family? Typical traps that we see out there is our only goal is to avoid probate. And if that's your only goal, I'll show you how to do that, okay? It's really just kind of like a math equation. It's really just titling things right. But you can miss many things by just avoiding it. So don't be short-sighted. But here's the primer on it if you want to learn how that works. So let's start with the basics. My engineers love formulas. So individual name equals will equals probate. So let's start there. Anything in your individual name is going to go through the probate process. It's like you own those assets through a will. And anything that's owned, anything that if you've done a will and that's the centerpiece to your plan, then you're driving your family to the court after death, which may be fine, but typically our clients don't want to have to deal with that. So that's where we start, individual name. Joint tenancy, okay? Joint tenancy with right of survivorship is a way to hold title to assets where when one joint owner dies, the asset will go outright to the survivor by operation of law. So it avoids probate on the first death. What happens on the second death? So you're just delaying the issue to where if it's a spouse situation, the spouse is in the grieving process. Now let's saddle them with all the issues now that we should have thought through initially. If we're going to do it right on the first death. Or if you add a joint account to it, like a sibling or a child, you're opening up a can of worms, all of their creditors, all their issues. Why go there? You don't have to do that. Transfer on death accounts. That's another way to title your accounts. Those are the bank's contracts. Just go ahead. And so, you know, anytime you have their contracts, it's always bureaucratic, red tape. And so the transfer on death accounts say, when I die, if you put that designation on the account, it will go to certain people. Again, there's a lot of risk associated with that, but if you want to avoid probate, there you go. Read the fine print. And then planning with the box or any of those accounts that you've set up. The most classic one is your IRA, if you have an individual retirement account or a 401k or TSP plan. It's those beneficiary designations. When you're laying out beneficiary designations, you're actually doing estate planning, right? This is where the money is going to go to. So you need to be counseled on what the options are. And especially with IRAs, there's a lot of income tax issues you need to be aware of that are very, you got to be, for the wary, you got to look out for. I did an article in the Financial Planning Services Journal several years ago. If you want to have a copy of it, I'll just show you quickly. It was a Supreme Court case that dealt with IRAs and the asset protection for IRAs, inherited IRAs. This is one that's not going to a spouse. Clark v. Ramaker said, no, we're not going to give creditor protection for inherited IRAs. And so this also goes through, I go through how you can integrate trusts with IRA planning if you'd like. So that's an aside. If you are interested in that, feel free to reach out to us. We'll get you a copy. All right, so those are some of the typical transfer traps. And so let's go into these. If you just wanted to avoid probate, I could structure things and we can avoid court, at least on the first death for most of the issues. But is that going to solve your problems? So contrast that, avoiding probate, just the only narrow goal there, with the real personal planning goals that we have found. And number one personal planning goal that we typically find, or one of the issues, is catastrophic illness protection or disability protection. If you have an opinion, if you did have that catastrophic illness, stroke, Alzheimer's, or the like, do you have an opinion if you'd rather be taken care of at home or in a nursing home, or you don't care? And so my point to you is, if you have an opinion, where in your legal documents does it say that? Typically what people get is an advanced medical directive or a healthcare power of attorney. That's a legal document designating your healthcare agent to make decisions for you when you can't communicate them to the doctor. And there's usually a living will component, the constitutional rights to die component as well. And so those are very boilerplate documents. They don't usually, they just basically say you can check me into a hospital, you can check me into a nursing home, you can keep me home and bring home care in, you decide. And so that's a tough one. Even if you don't care or have a very strong issue, strong feelings on your views of that situation, you're not doing the family any favors by keeping that to yourself, because they're going to be guessing. You're burdening them with that decision. Have the conversation. And so what we do is we use that we facilitate that conversation through checklists. We don't give you a blank piece of paper and say, figure it out. We've done this before. We'll make the checklists are there to support the conversation and are there to support the planning. We'll document them as well. Remarriage protection. I don't know why a lot of attorneys don't bring this up. It's not about trust between the husband, the initial married couple. The issue is between that new person. So let's say I introduce you to Bill and Mary sample, my favorite cast of characters, and let's say they have the I love you wills, very common planning strategy with the I love you wills. When Bill dies, everything goes to Mary, right? And then when Mary dies, if Mary were to predecease Bill, goes to Bill. And if they had 2 kids, after both of them dies, everything goes equally to the kids. Very common approach. So I'm just talking about remarriage protection. So let's say in our plans, our hypotheticals, we always have Bill checking out first. It's just an easy example. You can do whatever you want in your plans, right? So Bill dies, leaves everything to Mary. And let's say Mary goes down to the tennis club and meets Bo, the tennis pro, right? And they fall in love and she gets remarried. And let's say that Mary predeceases Bo, the new spouse, and her will says everything goes down to my kids. Even though her will says everything goes down to my kids, does Bo, the new spouse, have a legal right to her assets? In all 50 states, okay? In all 50 states, he does. It just depends on your jurisdiction, how much. It could be anywhere from 1/3 up to 1/2, depending on the length of marriage. Could be more if there's no kids. So you need to look at those issues if that's important. Well, at least the attorney should be raising those issues for you. The other point to that, okay, and that's a bigger point, is usually the title will trump the legal documents. So I've been saying over and over again, there's a couple themes, is that asset titling has been a big pitfall because people miss that. Well, title will trump the legal documents, and here's where it's highlighted. So in a married couple situation, let's say Mary married Bo, right? This is the second spouse. And let's say Mary has an IRA. Okay, if you have an IRA in a married couple situation, who's typically the beneficiary of an IRA? It's typically the spouse, okay? And so IRAs are contracts. It does not matter what Mary's will says. If Mary's will says everything goes to the kids, it doesn't matter. The custodian of the IRA is going to look to the beneficiary designation, and it's going to go to the spouse in that situation, okay? Life insurance, typically it's a spouse, or joint accounts, typically spouses are added. Joint accounts will go to the surviving spouse by operation of law. Doesn't go through the will, okay? So if there was a way that Bill could leave his assets to Mary, she could use it for whatever she wanted. When she passed away, it had to go down to the kids. Is that something that's worth spending some time talking about? Is that counseling? Is that word processing, right? And so it may be an important issue to you, maybe not. But again, it's like going to the trip to the eye doctor. I use my little eye doctor chart here. Is that I'm going to co-create the plan with you, and we're going to find out what issues are most important to you. The biggest question, or the biggest story in our firm, deals with creditor protection. And so I'm going to go over our school bus story. All of our clients know the school bus story. And this is dealing with what a revocable trust is, an irrevocable trust is, and the asset protection features and the non-asset protection features of them. So in this story, I'm going to use myself as the example. And in the example, there's 2 assumptions. One is I'm dead in the story. And then number 2, there's no creditor protection for me while I'm alive. Okay. And so let's say I've died, and let's say my wife, Nusha, is all distraught. She's not paying attention. She's driving down one of the roads. It's raining out. It's a little bit slick outside. She runs a red light. Bam, hits a school bus full of kids. Let's say one of the kids dies. Horrible facts. She hates herself. The world's against her. I don't have enough insurance or money in my estate to pay for these catastrophic creditors. So there's a couple different ways I could have left my assets to my loved ones. And I'm going to go through that with you now and the different asset protection features. The first thing I could have done is I could have done a simple will. And in the simple will, like I said, when I die, everything goes outright to my wife. I die, everything goes outright to my wife. She hits the school bus. Are those assets subject to her creditors? Absolutely, right? Anything I left outright to her, fair game for the creditors, they can take it. What if I title everything jointly? The house, bank accounts, the like. Title everything jointly with right of survivorship. Joint tenants with right of survivorship, or even if I'm married in one of the states that has tenancy by the entirety with right of survivorship, another form, a higher form of asset protection for married couples. But when on the death, the asset will go outright to the survivor by operation of law. So on death, now the creditors can put the lien on the house, can garnish the bank accounts. There is no asset protection for the joint accounts, okay? The creditor protection, the third way is maybe by contract. Let's say I had a life insurance policy, And on the beneficiary designation form, the box, right? I write my wife's name. And let's say the policy, not worth much when I'm alive, but when I die, it turns into $1 million. I write her name down. She puts $1 million into her account in her name. She hits a school bus, gone. Fourth way is by a bare bones trust. I review these trusts all the time. And the dispositive provisions of the trust say when I die, everything goes out right. Same problem, okay? So let's do my planning again. Let's pull myself out of the grave. Let's say I did my planning this way. Let's say I could have left my assets to my loved ones. They could use it for what they wanted, but if they hit the school bus, protected from their later creditors. So let me say that one again. They can use the assets for what they want, but if they hit the school bus, it's protected from their later creditors. So my question to you is, if you remember that definition of estate planning, is I want to give what I have to whom I want, when I want, in the way that I want. Here's one of the ways that you can leave your assets to your loved ones. So how many of you would like to leave your assets to your loved ones that way, protected from their later creditors? And so how many of you have been asked that question before? Is that counseling? Is that word processing? Whose job is that to raise, right? And again, that's that trip to the eye doctor, and there's a bunch of issues that we're commonly going through, and we just course correct, and we'll narrow them down to one or two options for you. But that's a very powerful planning technique. Now, one thing I want to disclaim is, anybody going to tell you that something is bulletproof and is 100% protected from creditors, that is just not the truth. Okay, so asset protection is about putting layers between you and a creditor, and putting obstacles. Okay, and this type of structure makes it very hard, very difficult for people to get to those types of assets. Nothing is bulletproof though. Okay, so that's divorce protection, and then, well, that's creditor protection. And then, so let me stay there for a little bit with regard to the creditor protection. So the reason why that you can protect those assets that way, I'm going to introduce you to the concept of a revocable living trust. And so think of a living trust as one that's created during your lifetime, as like an open bucket, which means you can get in and out of this bucket and get to the assets. And your creditors can as well. So the trust, back up, is basically just a legal document. Okay, it's a contract. There's three parties to it: the trust maker, person creating the trust, the trustee is the one managing the trust initially, and the beneficiary is receiving the benefit of it. So a living trust is a great way to centralize management of your assets, provide for disability planning, and also provide for asset protection planning after you die. So during your lifetime, no creditor protection in a revocable living trust. But after you die, you can put the lid over it and say, this is my hard-earned wealth for my beneficiaries. They can use it for their health, their education, and their maintenance, but not for their creditors' health. It's not for their creditors' bill, not my money. With their money, you can do with what you want. So that's a big distinction in the trust laws that are out there. And so revocable trust turns into an irrevocable trust at death, but you want that if you're the beneficiaries or the surviving spouse, because we can build it where you're getting a lot of protections there, and you can still get, there's still access to the assets as well. So that's creditor protection, and that is a revocable trust and an irrevocable trust, the difference between those two. Now, some of my clients who are worried about getting sued during their lifetime and don't want to wait till after death to provide creditor protection for others, you can create a trust for yourself, an irrevocable trust. There's different ways to do it. That's advanced planning, but that does provide creditor protection. The key with those types of plans is you cannot do that you can't be involved with any type of litigation. You got to do this in calm waters, or that's considered an intent to defraud creditors. If you're in a lawsuit, now you're trying to do these types of things. But very solid planning techniques done in calm waters and done with the estate planning side. So massive creditor asset protection benefits available if you want to take advantage of them. Divorce protection is really just leaving the asset to the beneficiaries. And the point is, how would you like to leave the assets to your beneficiaries and ensure that it stays with them rather than going with the new outlaw? So if the beneficiaries get divorced, the money stays there. Values promotion, I use the babysitter story. It's really just that non-material wealth. And so if you've ever had a kid and had hired your first babysitter or been a kid, right, and had the babysitter come over. The key with the babysitter story, and so we recently went through this, hired our first babysitter, and we were just going out for a nice relaxing evening for a dinner and a show, one evening, right? The babysitter comes over, and my wife's giving all the instructions. She's going to want to stay up late. If you read the book, read these books, and read every page, because if you skip a page, she knows. I don't know how she knows. She's going to want to try to get this toothpaste. Don't use that toothpaste. Our phone number is here. Our neighbors are here, right? So we're getting all these different instructions, and we're just going away for one evening for a dinner and a show. And so my point is simple. Would you agree that we leave more instructions for our loved ones when they're little, and we're just going away for one evening for a dinner and a show, than we even think about leaving in our estate plans when we're going away for a lifetime? So think about that one. And now it's not just a blank piece of paper and give us your values. We've done this before. So we'll give you checklists. We'll give you carefully designed questions to identify, record, and memorialize your legacy. So again, it's all about that trick to the eye doctor. So that's what estate planning is about, is going through and making sure those issues are covered and all the common issues that we see are addressed. And let's talk about those in calm waters rather than in the actual crisis, okay? So that's developing the plan with counseling-oriented planning partners. The next one is, the next step of our three-step strategy is that empowered legacy. It's that maintenance. Commit yourself and your family to a continuing maintenance and education program. So like I said, typically the majority of our clients are under our base maintenance program. And so these are ranges, but just give you an idea, for our maintenance program services, we charge $645 a year for most of the basic client services. And so what do those entail? We're not going to nickel and dime you for phone calls, emails, faxes, and letters. And so that is part of the deal. If you have a question, give us a call. We do phone appointments. That's a way we avoid phone tag. Word processing amendments, you got to change. We're not going to charge additional for word processing. We charge additional for counseling, not for word processing. Someone moves, someone names change, those types of things, no problem. Someone gets into a disability situation and you call us and say, now what? We'll probably have to do some counseling on that, and we'll let you know what it would be ahead of time. Every year we'll do an annual funding double check. Is basically we're going to do an inventory of your assets. We'll send you our asset review report that says, here's what you have disclosed to us, here's your inventory, here's our values. You give us the latest values, just make sure we've still got the right inventory, so that if something happens to you, we don't have to play Sherlock Holmes to go find everything. Cuts a tremendous amount of time and expense off of the administration. In the first year only, we'll do a family meeting at no additional charge, is where we'll sit down with the client and the family or any of the helpers and go over the plan as high level or as detailed as you want, with whomever you want. And it doesn't have to be live. It could be through the Zoom, video conferencing, or teleconference as well. Don't care where the education occurs as long as we get it. The annual client meeting, every year we do an annual client meeting. These are done in group format, either live or through the web. Typically we'll talk about what's going on with the law, how it impacts our clients' plans. Everyone will get their funding reports to determine where they are at on the funding, what's going on with the law firm, our team, our processes, our education calendar for the year. So just keeping you in touch with the law firm, making sure that you're good on that. Every other year, we have a biennial group document update where we'll actually update your plan every 2 years. And the way we do that is we have an executive summary of your plan of about 10 to 12 pages that we'll send you about 2 or 3 months before the updates. And we do leverage these as well in group format, do them live and also through the web. And so that is very powerful to keep the planning updated and having those services at those rates, because we're doing things in group format. Group educational programs, like this is one of the educational programs, but once you become a client, there's different educational programs like the 911 information. So if something happens, there is a death, what's the 911 information you need to know, who to call, frequently asked questions, what are the steps. We've got all of that. That's a typical one. different programs on different topics, and that's all through our website at www.insightlaw.net. Then DocuBank membership is like carrying your medical directives. You get a little credit card because you're probably not carrying your medical directives on you if you were getting into an accident, and that card is a way to keep the directives on you at all times. So that's just a big picture overview as far as what the Insight Law Maintenance Program looks like, just to kind of show you again the visual is early on. There are things that will change with regard to every estate plan, and early on in my career I would focus on the changes in your personal situation, changes in the law that occur all the time, and then changes in just different techniques. And people, I realized about 5 or 6 years ago that people understood that things change. It's just that they didn't want to pay the attorney for it. And so we said, okay, let's focus on the fee and focus on the services and be consistent with that and give them a whole bunch of value for that. And that's what the optional current rate is, $645 for the maintenance plan services. So the legacy program, the maintenance program, consists of, you have your asset review report is documenting the assets at any given time, big points into the planning. The estate planning review worksheet is the executive summary, so we know your instructions at any given point in time. And then we have the annual client meeting, touching base, making sure you're aware of the laws, the different techniques, what's going on with the law firm. Also, the update program is where we're actually updating the legal documents on a systematic basis. And then the family education and training program, mainly through the web. We have live events, and they're on our calendar of events, which is on the web. So we've set the plan up with counseling-oriented planning partners. We've maintained the plans. Now the third step is empowering that inheritance by securing appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So I don't know what appropriate assistance looks like to you, but to us, it's about controlling costs. Hopefully that'll, also full disclosure of the costs. And so hopefully that'll give you true peace of mind. So here's how you control costs in the estate planning world. Number one is full funding. So full funding, a lot of people ask me the question, what does full funding mean? What does trust funding mean? So remember I told you a trust is nothing more than a contract, and a contract that you're creating. You're the trust maker, trustee, and then the beneficiary can be you and any other people that are associated with your plan. And revocable trust, remember, is the one that's open bucket. And full funding means we put all of your assets that we possibly can in the trust, with one major exception is retirement plans, and we'll talk about those. But if everything is in your trust, then when you pass away, we could just pass that box or pass that trust on to the next person that online that you trust, and the administration can be done privately, not on the court schedule. There's going to be an administration, I'll talk about that. But if we're not on the government schedule, that's going to reduce costs if that communicates, okay? The IRAs, just as an aside, IRAs or contracts are going to avoid the court process, but we got to make sure that the beneficiaries are done properly. So spouse beneficiary, trust beneficiary, child beneficiary, what's the best way to do it, get the maximum amount of protections? Well, that just depends on your situation. And then, so that's full funding. The other main thing with IRAs is making sure that you have a valid power of attorney that is respected when necessary, when needed, if you are disabled and a distribution needs to be made. Another way to control costs is proactive trustee and beneficiary training. Educate the people that are going to need to deal with winding down the plan ahead of time, so that you know, hey, they've engaged. If you've engaged us, engaged Insight Law, there's a process. Here's the steps. This is what you go through. It's very predictable. Okay, and so that reduces costs as well. And then we have a proactive engagement approach. Is if your family is in our maintenance plan when they pass, then we will do the administration if you hire us at that time. We can't ethically bind you to hire us, but we know where everything will be at that time, and we have a very strong process for that. So that's how you control costs. Full disclosure of the cost, and let me just hammer the point home with funding, because a lot of people will create trusts, and one of the first questions is when people ask me to review the trust is it fully funded? They don't know what I'm asking, or they say it's partially funded. Funding is putting all the assets in the trust with some, exceptions, major exceptions, but that's typically where most the time people won't have the assets titled to the trust because maybe the attorney left it to them when they did the initial planning. They didn't price that into what they were charging because it's tedious, time consuming to do all the titling paperwork to get everything in the trust. We do that. So that's part of our process, part of our fee. We'll show you how we do that because it's just the stakes are too high. If you miss an asset, then you could go through probate on those assets, and that frustrates the purpose of the trust. And so partially funded trusts are actually causing the families a lot more work than if they didn't do it at all. So that's one of the first questions I ask. So understand what trust funding is, understand that it's important if you've gone the trust route, and then the impact of it. Full disclosure of costs. So for us, we're very transparent. I'll show you our business model, how we set fees right up front. We'll have the cost of the initial counseling and the documents. That's the setup fee. The cost of updating the plan. I've already told you ours is $645. Most people fail to update the plan. And then the cost after death. Most people don't even look at the cost after death. And a lot of the costs are back-end and loaded. So let's go there first and go through what the costs after death look like typically in an estate plan. And so what we have, what I'm showing you here, is the Virginia schedules. Every state has their own. I've got Virginia here. I got Maryland here as well. So I'll show you in Florida just to give you some examples. So this is the fiduciary schedules for if you have a will and you're going through probate in this county. And so if you have a probate, then there's going to be some fiduciary, there's going to be some fees to deal with the probate. And typically what happens is a family member is listed as the executor doesn't know what they're doing, the family member doesn't know what they're doing, they hire an attorney, and the attorneys are charging under these fee schedules. Whether they charge the whole fee schedule or not depends on the situation, okay? But these are the guidelines. And so if you had $1 million go through probate, the first $400,000 can be charged at 5% to administer those. The next $300,000 can be charged 4% on those, and then the next $300,000, 3%. So it's a percentage scale. Those percentages are pretty high. Montgomery County, Maryland has 3.6% of anything over $20,000. So every state has a different way of looking at those. The Florida statutes that I put here, so the Florida statute, there's two reasons why I put the Florida statutes in here. Is Florida, would you agree, has a strong senior lobby, right? The joke is God's waiting room, right? So Florida is one of the few states that put a cap on what an attorney can actually charge to do a trust administration. So I know I'm getting in the weeds here, technical here, but you need to understand this because this is how the fees are structured. And that after death, Florida said, okay, if you have a trust, then we're going to have, you're going to cap what the attorney can charge to do the trust administration. We're going to cap the rate. And so number one, there's two teaching points there. Number one is that people think that, hey, I've done the trust, that the trust is a magic book that when I die, we use these nice red books to keep all of our legal documents in, that when the death occurs, the trust will sprout arms and legs, jump off the shelf, inventory the assets, value it, track it all, transfer it, and do the administration, because death is a major life event. It doesn't matter if you die with a trust or will, there's still, all your affairs have to be closed out. It's just a matter of being on the court's schedule or not, okay? So that's number one teaching point. And then number two teaching point, it gives you a good idea of the market rate with Florida being such a strong consumer protection rate. And so they say, this whole paragraph 3 right here says compensation for ordinary services based on the value of the trust assets immediately following the settler's death and the income earned by the trust during the initial administration at the rate of 75% of the schedule provided in this 733.6171 is presumed to be reasonable compensation for attorneys in the initial trust administration. So 75% of this schedule, and this schedule is right here, and it's on a percentage scale, go figure, just like most states are out there. And so Florida state percentages are a little bit lower because they're such a strong consumer protection state. So if you had an estate between 100 and 900,000, charge 3% of that. The reasonable compensation for trust administration would be 75% of that, okay? And then 2.5% between 1 and 3 million. Do the math, all right? So that's kind of what's out there. If you're a reader, I'd be happy to send you an article on that. Just email us and let us know if you want that. Here's how we set our fees. I'm going to put those up for you right now. So we have two options, fixed and variable option. Most clients take the fixed option, but as long as you understand what we are offering and that we're not offering the same things as people off the street, okay? And so we just went through the settlement administration on the fixed model, and you just saw the percentages that were out there, 3, 4, 5%. We'll do the settlement administration at 1.25% on the size of the net estate. We'll cap it there. And we'll only do it if your successors hire us at that point in time. And so we're going to be a lot lower than those market rates out there because of the maintenance plan, right? So the $645 a year will cover us to make sure everything is fully funded, titled, we're not going through court, the family's educated, you know the process, that the plan is tight. In year one, to get everything title right, and that's where a lot of times that's when the titling and everything will be left to the client, we're going to manage that, okay? So you're going to enroll in our maintenance plan, and we're going to require the first year, but after year one, it's optional. We're not going to lock you into anything, but we have a very high renewal rate. So year one, we'll enroll you in the maintenance plan. That's $995, a flat fee. Now, these are ranges. If you've got like 20 pieces of property, we're going to talk because the recording fees alone are going to eat those up. But these are generally what the fees are looking like. The upfront cost of the counseling and design for the documents per family is 1/2 of 1% on the size of the net estate, subject to a minimum and a maximum. Our minimum fee right now is $4,000. Our maximum fee is $12,500. Where you land on that depends on your goals, the nature of your assets, what you're trying to accomplish, and we'll let you know ahead of time. Whatever the fees would be disclosed in advance. And this is typically for most families, if you're doing base planning, under the current laws, that covers you up to $22 million in assets for the federal tax laws. If you live in different jurisdictions with a state estate tax, that'll be different, and we would talk about customizing that at that point in time. It does not cover Medicaid planning. Medicaid planning is advanced planning and irrevocable trusts, and so we would look at those options as well. But if you get things done ahead of time, it's going to be a lot cheaper than if it's crisis planning. So that's our fixed model. There's an upfront cost of the setup, the investment, and then after that, it's just enrolling in the maintenance plan and just maintenance, and then at death, the administration side of things. And on the variable side, if 1/2 of 1% on the size of your net estate is too high for you, then we can go with 1/3 of 1% on the size of your net estate. The minimum is still $4,000. Our maximum there is $10,000. The difference between the two is that the back end fee will go up on the variable option. We will charge, instead of 1.25%, we'll charge 2% on the first tax coupon. And we haven't gotten into taxes yet, but the first tax coupon currently is $11.4 million. The second tax coupon is $11.4 million. That's scheduled to change in 2026 to $5 million index for inflation. I don't know where Congress is going. I do know I have a meeting, and we'll update it, and we'll make sure we course correct as necessary. That's how we structure our general fees, okay, fixed and variable options. And then on the back end, our business model is pretty transparent as far as our cash flow. We don't necessarily get more cash flow. We have less clients and better relationships. So we're not some type of trust mill where we're trying to get you in and then go to the next client, get you through, get to the next client. We're going to stay with you, make sure everything's title right, make sure your family's educated, and just stay with you during the planning rather than you're just a file and then we're going to the next person, and then when something happens 20 years, trying to recreate something. Doesn't make sense. The maintenance plan has typically been a loss leader for us from a financial standpoint because we are going back to the client's files. We are going back and making sure that we take care of all of them and follow through on our commitments. But guess what? We're getting client referrals, and so this is actually working out great for us in that if you do the right thing by the client, you're going to get referrals, and everyone you get similar types of clients that what we're looking for. And then the settlement and administration is very predictable. We've done a lot of the administrations, haven't had to go through probate on any of ours. It's not a guarantee. It's just really bragging rights. We're very vigilant on that. And so we're take pride in having a very smooth settlement process, supporting the family during the most difficult times. That's how we set our fees. While we're here, I'm going to go through our process chart, and then I will end with the IRS supermarket story, and then I will with taxes, and then I will adjourn. Okay, so our process chart is as follows. You're currently at the initial step, the Truth About Estate Planning experience. This is with me. There's no charge. It's in group format or online. It goes through our process, philosophy, fees, different options, and see really vetting each other to see if it's a good fit. If you say this is something that's worth exploring, the next meeting would be the discovery dialogue. That would be with our associate attorney, currently Wendy Masimer, and she would be going through the goals with you, go through your personal information form. As part of this meeting, you'll get a personal information form that asks biographical data for you, and also asks you about the nature of your assets, how they're titled, and the beneficiary designations, because literally we're going to go through each asset and make recommendations for you, and it'll help you, okay? And so she's going to review that personal information form. There's no charge for that discovery dialogue meeting. It's usually about an hour. She can do it live or through the web. She will do a goal setting exercise with you. She'll give you a tight fee range based off of what we talked about today. This is what you're looking at based off of your goals and your assets. And then she'll answer any questions that you have. Then the next meeting is with me, the initial interview. That's typically about an hour, hour and a half, depending on questions. I will go over engagement agreements, go over all of the services of the firm, scope of services, and we'll decide together whether it's a good fit. If it is a good fit, then we will sign and get all the engagement agreements in place. And that's where that first half of the design fee would be due, is when we start the design of the plan. And we would get into the design of your plan at that point in time. And then the design meeting is typically with myself or Wendy. That ranges anywhere from 2 to 4 hours. I would never, really draw out meetings more than 2 hours, maybe 3 hours, depending on how you're doing. So we break up those meetings if necessary. And the key is it's getting the good quality of thinking, right? So the quality of everything that we do depends on the quality of the thinking up front. So we'll spend some time making sure we get the right issues down. And then the next meeting is a delivery and review meeting, typically with our associate attorney, Wendy. And that will be a review of the plan, make sure that you understand it, answer any questions that you have, sign, formalize, make it legal. And at that point in time, the second half of the design fee would be due at that meeting. After that is the financial strategy meeting. That's typically with me. That's where we'll make sure there's no charge for that meeting. We'll make sure that the estate plan is coordinated with the financial plan. Make sure we have an accurate inventory of your assets. I will literally go through and make recommendations. If you have a financial advisor, tax advisor, or whoever you trust, they can be part of the meeting. We can get their weigh in on items, all about collaboration and all about you and making sure the plan is right for you. The funding meeting is run by our funding coordinator, Ginny Oliver, and that's where she'll have all the magic forms to get everything titled into the trust. Remember, that's one of the biggest pitfalls. We'll coordinate or manage that process, which is big. That's where that $9.95 enrollment fee is due for the maintenance plan. The optional family meeting is no additional charge if it's done within 6 months of the delivery of your plan. We'll go over the plan as high level or as detailed as you want with whoever you want. And then you're just on maintenance. That's that $645 renewal every year currently. And so that's our process pretty much in a nutshell. And typically, once you're motivated, once we get started, you'll have your documents in your hands, usually within 6 to 8 weeks, and then we get into the funding process. Okay. I'm going to hit a couple more items on the PowerPoint, but I hit most of the items that I wanted to, so I'm going to gloss through a lot of the back end side of items. But for the costs, just remember when you're looking at costs and comparing them, what is the attorney doing for you? Are they going to be updating it? Are they going to fund it? Are they going to settle the affairs for you? Is everything titled right? And so those are things you just got to know to ask the right questions. And if I could check in with our sheet, let me see how I've done on our review sheet. And these are the questions I would be asking the attorney. So the first question I would be asking is, please tell me about your interest, background, and experience in the planning field. What percentage of your estate practice is in estate planning? So for us, we do about 60 to 65% estate planning, 35 to 40% business planning. We don't do litigation. We're not doing personal injury. These are our core competencies. How do you define estate planning? If you remember, that's our definition of estate planning. What's your counseling philosophy? If you remember, that's that pyramid where you teach us the family, we'll teach you the law, and together we'll make the plan work. But every family is different, and we got to make sure that we got your goals down clear. What is your process for working with me? I just find process produces predictable results. I just showed you our process chart. I would ask the attorney if they have a process chart. How will you counsel with me to design my plan? I use visuals, stories. I call it that trip to the eye doctor. To me, the legalese, we've got it. It's important, but communicating with the clients and making sure that you understand, I think the stories are really valuable because they a lot of times will survive the storm of a settlement or a grieving issue. How do we assure that my assets are controlled by my instructions contained in my planning documents? Who's responsible for this coordination, you or me? I'd say number one common pitfall with planning is people don't have their assets titled right. So that's the process of trust funding and the like. I spent some time on that, so make sure you're aware of that. How do we assure that my plan stays current with changes in the law? That's our maintenance plan. So we have a formal plan, just a very strong process. We're on year 12 of it, okay? And so we take a lot of pride in that, and it's really important to us. What's the level of involvement of my family in the planning process? Obviously, the more involvement we feel is better, transparency and communication. Every family is different, so we don't force it, and so that's the point on that. How do you charge for services? I showed you how we charge. I showed you how we charge after death. Our disability program is very strong, so there is hardly anything on that because it's such a strong issue. But a lot of times disability will really crater a plan because people haven't thought through the issue. What's your record with regard to probate? So again, we haven't had to go through probates on the trust-based plans that we've created. Not a guarantee, but I would ask that of the attorney, and I would ask if they do have living trust-based plans, how many of those wind up being probated? So they shouldn't have a lot of probates if they have a lot of living trust-based plans. Do you handle the filing of the death tax return? So yes, we handle that. That's part of our deal. It's part of the administration. What if something happens to you? So I didn't go through all the bios, and the bios are on our website at www.insightlaw.net. I have a backup attorney. His name is Ed Clay. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his if he gets hit by the bus until I find feel my internal succession plan with my internal team is good. But you would be working, how do I prepare for our consultation? Is you would complete the personal information form that would accompany this. It's just one per family. And then what type of service should I expect from you? You'd be working with everyone on our team. Obviously, you'd be working with me a lot, but everyone has a strong, has strong characteristics, strengths, and weaknesses. So Ginny's going to be great with the titling of the assets. Wendy's going to help a lot with the titling and the settlement and then the drafting. Michelle will get all of the coordinating done and the scheduling. So it's a team approach, and it brings much more value to you on that. And then do I expect any commitments from you? Just complete the personal information form. The reason why we're asking for how things are titled is that we will make recommendations for you. So with that being said, those are the main items that I wanted to address here with everybody. I'm going to just check back in to see if there's anything else I wanted to hit before. Just a follow-up on the fees. Just So a couple follow-up items on the fees are, I'm a big Paul Harvey fan. Dating myself, I would ask, ask the attorney, what's the rest of the story? So ask them what they're charging for the trust settlement administration, death settlement, death tax return preparation. You know, what we find on our maintenance plan is typically there's an initial investment, but then it's just pretty much very predictable and controlled costs. Traditional planning is you just don't know what you're getting. It's just kind of pay as you go, and it can really blow up on you. So it's dangerous. The cost after death, remember traditional probate is anywhere from 2.5% to 5%, given those guidelines, fee guidelines. Standard living trust planning was those Florida fee schedules, which gave you that 25% discount. Our planning process, what we've seen for the entire life of the plan, is typically 1% to 2%, which is typically lower. That's not what we're committing to on this. It's just something that being proactive actually, it works and it's more efficient in the long run. Hopefully that'll give you true peace of mind with regard to it. So the last thing I want to bring up is just on the tax side of things, and then I will end with like the whole iceberg. So for the estate taxes, I'm not going to get into the details. I do have a much more detailed story on my website if you are interested in hearing. It's called the IRS Supermarket Story. You can pull that up off of the website. But basically with regard to estate taxes is that pretend that we have this IRS supermarket of life, and everything inside the supermarket is subject to death tax. And in a married couple situation, we have a husband shopping cart, we'll say a wife shopping cart. Everyone has a coupon right now worth $11.4 million, which means that you can each die with up to $11.4 million worth of assets, 22.8 total if the planning is done right, and not have to pay any federal estate tax. Okay, anything over that is hit at a 40% estate tax. That law, that coupon amount or exemption amount, keeps changing. That's scheduled to come back down to $5 million indexed for inflation in 2026. Again, I'm not guessing where Congress is going, so you just need to be aware of that coupon amount and that there is a number there that's larger now, will come back down, and depending on who gets elected, will change with regard to that. And then if you happen to live in certain states, some states have a state estate tax. There's a handful of them. States like Maryland have a state estate tax at $5 million. District of Columbia, $5 million. Index for inflation. State of Washington, $2 million and change. Every state, every state's got. You got to make sure that you've looked at the laws. So, coming where you're coming in from, we'll make sure that we've got that covered for you. So that's estate taxes in a nutshell. The main other point that I'm not going to get into now with regard to estate taxes is if you had a trust done, and we're in 2019 now, if it was done more than 10 years ago, you definitely needed to get it reviewed for the tax provisions. There's something called portability that was made permanent, and so the trusts that were done pre-portability, the attorneys were thinking one thing, and rightfully so, because portability wasn't out yet. But they're missing that key language now that portability has been passed. And so that's an income tax issue for your beneficiaries. Again, beyond the scope of this discussion, it's just something that I'm bringing up to make sure that you understand it's relevant. And we would definitely get into at that time. So when you're going through the estate planning, look at the whole iceberg. And so traditional planning has been typically looking at and comparing it to the modern approach. The traditional approach is just getting your basic documents done and focusing on the documents and getting questions answered. The modern approach is so much more, and you deserve it. It's really where we're at now. And basically, it's getting counseled on your options and making sure you understand your options and you make the choices on those. We'll give you recommendations. Making sure things are funded, titled right. Maintaining the plan. Making sure that the plan is updated. That not only you are educated, but the key family members or key helpers are educated. That when if there is a disability event, that we have a process to get your family through. And other things to support the surviving spouse, making sure that there's a plan to support the surviving spouse. And a strong process for settlement. So we're looking through the whole plan to the end of the plan, and that's the way it should be done. And so with that being said, I'm going to conclude the program. If you are interested in working with our firm, then you're going to email the initial email that I gave you is mt@insightlaw.net. Let me go ahead and bring you to the beginning again. And she will take all of your mt@insightlaw.net is Michelle. And if you are interested in a discovery dialogue request, there's no charge for that. The personal information form needs to be completed. If you had a spouse come to the live program and you're watching the video, then as long as one of you completes it, that's fine. If you're just coming in straight from the online, then that needs to be completed, and Michelle will send that to you and let you know the information that you need to get you scheduled. With that being said, this has been Bobby Fazy, President of Insight Law, estate and business planning attorney. Hopefully this information, this client orientation meeting has been helpful for you. Thank you very much and have a good day.